In this video, we will distinguish between two closely related topics under Article 2, cancellation and termination. Unlike so much of Article 2, the concepts of cancellation and termination are somewhat straightforward and self-explanatory. Though cancellation and termination may sound like the same thing, both are distinct concepts under Article 2. But the importance of this distinction will only become more evident later in this course when we cover remedies for breach under Article 2. For the purposes of this week's module, the relevance of cancellation and termination is that both may excuse a party from further performance under a contract. So what is cancellation and what is termination, and how are they different? Both terms are defined in subsection 106 of Article 2. Let's start with termination first. Termination is the right of either party to put an end to the contract for reasons other than breach. Upon termination, all executory obligations under the contract are discharged. That means that both parties are discharged of all remaining and unperformed obligations under the contract. Stated differently, neither party has any further obligation to perform under the contract. But importantly, any rights or remedies that accrued from obligations due before termination are preserved. So, to the extent there was a breach of an obligation before the termination, the non-breaching party still has a right to a remedy for that breach. But as to any future obligations or duties under the contract, they are discharged as a result of the termination. There is no liability for either party. Stated differently, all further performance obligations under the contract are excused as a result of the termination. The right to termination may arise from the express terms of the party's contract. Here is one example of what a termination clause in a contract might look like. Press pause now to take a moment to read it. Pursuant to a termination clause like this one, the parties' agreement might state a specific date for termination or specify other events that would terminate the contract. Such clauses are common for installment contracts. Remember, unlike other sales contracts, which may be one-time transactions between a buyer and a seller, an installment contract contemplates successive transactions for the purchase and sale of goods in multiple installments. If the agreement does not expressly state the circumstances under which it may be terminated, Section 309, subsections 2 and 3 provide a gap filler or default rule. That default rule says that either party may terminate at any time upon reasonable notice to the other party. Specifically, subsection 2 says that unless the party's agreement says otherwise, the party's agreement may be terminated at any time by either party. And subsection 3 adds the caveat that any such termination requires reasonable notice to the other party. Like any other right or obligation, a contract party's right to terminate the contract is subject to the implied duty of good faith. What is not clear is what kind of termination would violate the good faith obligation. Some cases, like the Santa Fe Custom Shutters versus Home Depot decision in your reading, have ruled that the duty of good faith does not require the terminating party to have a reason to terminate. A party may exercise its right to terminate for any reason or no reason at all. The rationale for this holding is that if a contract party wants security from termination at any time, it should bargain for it and not rely on the implied duty of good faith to provide it with that kind of security. So that covers termination. What about cancellation? How is cancellation different than termination? Cancellation is distinguished from termination in subsection 4 of 106. That subsection says that cancellation is the right of a non-breaching party to put an end to the contract in the event of a breach. So cancellation is essentially a remedy for breach. As we will see when we cover breach, in most cases of breach, one of the remedies available to the non-breaching party is to cancel the breached contract. The consequences of cancellation are similar to termination. Like termination, upon cancellation of a contract, all remaining and unperformed obligations, that is, all executory obligations under the canceled contract, are discharged. Stated differently, no party is obligated to further perform under the canceled contract. But simply because cancellation discharges any further performance obligations under the party's contract does not mean that those discharge obligations are excused. The non-breaching party retains any rights and remedies arising from the contract. That includes damages for any breach that occurred prior to the cancellation, as well as any damages incurred from any unperformed obligations that are discharged as a result of the cancellation. To give one example of cancellation, consider a contract in which the seller simply fails to tender the goods on the date the goods were due. So the seller has committed a breach. In that case, the buyer, the non-breaching party, may cancel the contract, and as a result of the cancellation, the buyer's obligation to pay the seller for the goods is discharged. But the cancellation does not affect the buyer's right as the non-breaching party, to also seek damages against the seller for the seller's breach. As we said, we will come back to cancellation when we look at remedies. As we will see, cancellation is an important initial remedy available to the non-breaching party when a contract for the sale of goods is breached. So to summarize, in this video, we defined and distinguished the closely related but distinct concepts of termination and cancellation, and we identified the consequences associated with each. In the next video, we will continue our look at issues concerning the performance of a contract for the sale of goods when we look at insecurity and repudiation.